Okay, I'm here with Peter Libman, who teaches at Humber College and who is also a deputy small claims court judge. And we're here to talk about small claims and court enforcement procedures. Welcome, Peter. Thank you very much for speaking to us today. And I just wanted to ask you a few questions about enforcement today. What do you think the biggest mistake is that creditors make at a judgment debtor examination, whether they're self-represented or I'm sure you see paralegals and legal counsel in small claims court as well?
I think the biggest mistake is they don't know what questions to ask. Their focus should be on how to collect, not to relitigate whatever the cause of action was. And they should be thinking about, does a person have a bank account? Are they working? Do they have assets like a car, perhaps a house that you can collect from? They tend to go all over the place in terms of their questioning. They really don't do their research, which they should do before they get to the judgment debtor examination. Even representatives often try to wing it, and that's not a good idea.
Is there anything wrong with just showing up with my checklist and kind of going down a checklist, or?
Well, the trouble is, I did this for about 3 years straight, and often I would deal with over 100 cases in a single sitting, one sitting at 9:30 and the other 12:30. And it can be very frustrating to me as a judge when people would ask things about where do they live, that's fine. And then they would ask things about, do you have a TV or do you have a refrigerator? How big is it? What the make is? Because if you were to seize that, the value would be very slight. So they spend a lot of time on questions really that don't assist them. So they have a checklist, but they don't listen to the answers. They just feel they have to ask all the questions on the checklist.
Okay, that's very good. I've shown up at one of these debtor examinations with a corporation, and I'm trying to enforce against a corporation. And then you get these kinds of games where the person claims the accountant has the books and records. I had somebody show up with a shopping bag, literally a shopping bag full of, documents. I've also had people say, well, I'm on the board of directors. My husband put me on. I know nothing about this corporation. Do you have some advice for, how do we approach a corporation in an efficient way so we're not showing up with and maybe somehow deal with these sort of games that our debtors are playing?
Well, the first thing you should do with a corporation is do a corporation profile search. See who's registered with the Ontario government, if it's an Ontario corporation, as the director or officer, because those are the people under Rule 20.10 that you can summons to the court to answer questions. So people that say, well, I thought the lawyer took my name off, or I didn't know I was an officer or director, if the Ontario government shows them, then they're liable to answer questions. And if they don't answer questions, then under Rule 20.11, they could be found in contempt, and they could be sent to jail for up to 5 days. So they do have a legal responsibility to answer questions. The question about the accountant, I get that all the time. And people have to be aware of Rule 20.10 sub 5 that says that any other person can be summoned to answer questions. So if the person is deferring everything to the accountant, then summons the accountant to come to the judgment debtor exam, specify in the summons that they bring all the books with them, and then they'll have to answer questions. Or again, if they don't show up, or if they show up and do not bring the books or do not answer questions, they're subject to being found in contempt.
Okay, so I would be asking the judge to adjourn it at this point if I have the person up and say, okay, I think it's appropriate for us to summon the accountants and just to request a new date, or how does
That's right. And what I did in the past is I would make an order as a judge that accountant so-and-so be required to attend, and I'd give a specific date for the accountant to attend.
But I'm going to have to personally serve that accountant.
They should be personally served if you've got any doubt in your mind that they're not going to show up.
Okay. I just wanted to, maybe you could describe a situation in which you felt that the judgment debtor was likely to be held in contempt. Obviously, if they just sit there and refuse to answer any questions, or they refuse to attend hearings, but sort of maybe these kind of borderline situations, and sort of how that might be handled in a judgment debtor examination if we come up against that.
Well, what the judges are doing now, and I think you saw Judge Mintz doing that examination that you watched, he gives a checklist to the debtors of all the documents he wants them to bring. So if they don't bring their receipts for the rent, they don't bring a copy of the lease, they don't bring their bank statements, then there is a jeopardy that they could be found in contempt. And it's important that there be a written record of what they're to bring. So that's one way of dealing with it.
You're saying the judge actually sends that to them through the court, or?
No, when they show up,
Okay.
they're given a checklist, because often they don't bring anything.
And then
and
you
the
just
case gets
adjourn it
adjourned.
to another date.
Yeah.
Okay.
Now, just going back to the other question, many people transfer all the assets out of their name into, say, a spouse's name to avoid their obligations. And then every time they're asked a question by the creditor, the person says, I have no income, I have no assets in my name, they're all in my spouse's name.
Okay.
And again, you have to be familiar with the rules that the spouse can be summoned to come to court to answer the questions, since everything's in their name.
Okay.